Hi, my name is Courtney Buchan. I am a licensed community associations manager. I'm also a board member myself, and I'm currently the corporate trainer for GRS Community Management located in Lake Worth, Florida. I would like to thank Jeff for organizing today's webinar and Kay Bender-Rembaum for presenting it, specifically Kerstin Henze from Kay Bender-Rembaum's Tampa location. Kerstin is a firm member and the managing attorney at their Tampa location. She does many presentations, webinars for board members and property managers, like today's presentation on condo board certification. So a little bit more about the management company I work for. We're located in Lake Worth, Florida. We've been around since 1989, providing great, reliable service. We manage communities along the east and west coast of Florida. We have over 200 communities that we manage. If you're a board member, Cam, or anyone that has close ties to the world of association management, we welcome you and we hope to see you at future presentations. Follow us on Instagram, LinkedIn, X, and Facebook for more information and future webinar presentations. Feel free to reach out to me via email at cbuchan@grsmgt.com if you have any more questions. So today, Kerstin's going to be covering condo board certification. Welcome if you're a new condo board member. Welcome if you're a returning condo board member, as this is a great refresher course and it covers many topics. So today's class is going just over the basics because this is 2 hours. We can't possibly cover absolutely everything. Kay Bender-Rembaum does a great job of providing many webinars and presentations to elaborate on various topics across all of HOA and condo membership and management. So go to their website at kbrlegal.com and look at their calendar view to join future presentations. So again, if you have any questions or concerns, you can feel free to reach out to me. Our email addresses should be on our video camera. And again, I'd like to thank everybody for attending today's webinar presentation. We're going to keep questions towards the end. We'll open the Q&A towards the end. I will be helping out, answering some of the questions as Kerstin's going to be doing the presentation. Just keep in mind, I am not an association attorney. This is not legal advice. I'm just going to answer basic, simple questions. Please keep questions basic and not so community specific. And we'll do our best to answer your questions at the best of our ability and as fast as possible and get to as many questions as we can. So with that being said, I'm going to hand it over to Kerstin to start today's presentation.
Thanks, Courtney, and thanks, Jeff. Hello, everyone. Thanks for joining us this afternoon. My name is, again, Kerstin Henze. I'm the managing attorney and partner with the law firm of Kay Bender-Rembaum. For those of you that are not familiar with the firm, our main office is down in South Florida, in Pompano Beach, Florida. But we also have offices in Palm Beach Gardens, in Orlando, and on the West Coast as well. So the West Coast office is located here in Tampa, and I manage that office. I've been with the firm 14 years and practicing 15. So 14 of those years have been exclusively in community association law. That is the one and only practice area that this firm practices, okay? And we represent condominium associations, homeowner associations, and then co-ops as well. All right, so let's go ahead and dive into today's seminar. Let me pull up the slides. Give it a minute. Can you see those?
Yeah.
Can you see it, Jeff?
We just see the just hit from the beginning. Yeah, now we're perfect.
We
Absolutely.
All right.
All right.
So folks, there's going to be, there's a lot of words, a lot of pages. I am not going to be reading through most of these. I'm going to highlight the important information, but please, at your leisure, go through them. There's a lot of information here. And as Courtney had mentioned, this is really just the very, very basic of condo law. Okay. All right. So association board member certification. Why are we here? Well, you're here because the Condominium Act, which is Chapter 718, says that within 90 days after being elected or appointed to the board, you have to do one of two things. You have to either attend a division approved class like this one, or you have to sign a certificate certifying in writing that you have read your governing documents and that you will uphold to the best of your ability the governing documents and will faithfully discharge your fiduciary responsibility. Okay, so it's not attend a class and sign the certificate, it's one or the other. Okay, if you choose to attend a division approved class, you can either do the class within 1 year before being elected or within 90 days after your election or appointment to the board. Okay. And not sure why we're not moving to the next slide. Okay.
Slight delay there.
There we go.
Now we see it.
Now, as long as you serve on the board uninterrupted, you don't have to do the certification or attend the class. Okay. So once you attend the class or you sign your certificate and you file it with the association, you're good to go as long as you serve on the board. Okay. Now the certification or your educational certificate or the other certificate are good for they are part of your official records and they have to be retained for at least 5 years. Okay. Now, condo association generally. Okay. Condominiums exist under Chapter 718 of the Florida statute, which is also known as the Condominium Act. Now, there's one other statute that governs condominium associations, and that is Chapter 617. That is the chapter that governs non-for-profit corporations. Okay, as you may be aware, your association is an entity. Okay, it is a corporation that is non-for-profit. And when your association was created, it was required to file articles of incorporation with the Division of Corporation in Tallahassee. Okay, and so your association is also governed under Chapter 617. Okay, now you will also have a declaration of condominium. Okay, and other governing documents that comprise your entire governing documents, which would be your articles of incorporation and your bylaws. Okay, but it's the declaration of condominium that's really going to be your supreme document. It is the one document that's going to contain all your use restrictions. Okay, it is the contract between the owners and the association when owners buy into the community. Now, all owners also own an undivided interest in the common elements. Okay, the condominium is comprised of common elements and the units. And your declaration of condominium will identify the boundaries. Okay, so a unit owner that purchases a unit at the condominium also purchases an undivided interest in the common elements. Okay. Okay, sorry about that. All right, powers and duties. The condominium association is responsible for the operation of the affairs of the condominium. Okay, now some of the general powers that the association has, again, are found either under Chapter 617 or 617 or 718. And they include the power to sue, to be sued, the power to purchase, acquire property, to sell, to mortgage, and to incur liabilities, to borrow money. Okay. Now, which year's statute applies? Generally, the substantive law that applies to the condominium is the law that was in effect at the time that the declaration was recorded. Okay, so if you have a declaration of condominium that was recorded in 1975, typically that's the law that applies. However, you may have heard of a term called Kaufman language. Okay, so if you have a declaration of condominium that has the magic words as amended from time to time after reference to the Florida statute, okay, so your declaration would say, you know, this condominium is subject to 718 as amended from time to time. If it has this magic language, then that means that any changes that are made to 718 will automatically be incorporated into your declaration of condominium without having to amend your declaration. Okay. Now, if you don't have this language as amended from time to time, then a constitutional argument could be made that certain changes in the statute does not apply to the association. And primarily those would be substantive changes. Okay, there's two types of changes that could be made to the statute: procedural changes, and those would typically concern, you know, voting rights, election procedures, you know, that type of thing. For example, condominium associations are regulated, you know, for elections. So elections you have to conduct in accordance with the statute, not necessarily in accordance with the procedure of your bylaws. Okay. So if there's any change that's done to 718 with regard to elections, that's a procedural change and will automatically apply to your association, regardless of what your documents say. Now, substantive changes to the statute, those affect vested rights of owners. Okay. A good example would be a change in the statute that was made years ago regarding leasing. Okay, and the statute says that if you amend your declaration to prohibit leasing, okay, or limit the number of times an owner can rent in the condominium, those amendments would only apply to those owners that voted in favor of the amendment, and then those owners that took title after the effective date of the amendment. Okay. Now, if your declaration has the amended from time to time language, then that change in the statute, which took effect in 2004, would automatically apply to your community. If you don't have that language, then again, a constitutional argument can be made that this provision in the statute does not apply to your community. And so if such an amendment prohibiting leasing in your condominium is properly approved by the necessary voting interests, then you could say that it applies to everyone. Okay. Now, I think I just talked about that. Now, in terms of conflicts of interests, conflicts between the declaration articles and the bylaws. Okay, like I'd mentioned, your declaration is going to be your supreme document. Okay, it's the one that contains your use restrictions. Underneath that, you're going to have the articles of incorporation, and then underneath that, you're going to have your bylaws. Okay, and the articles and bylaws, they really outline more of the corporate structure of your association. So who are the members, who qualify as members, who qualifies as a director, how many directors must serve on the board, that type of thing. Okay. Moving on to transfers. Okay. A transfer fee, also known as an application fee. Okay. The Condominium Act says that you can charge a fee, which right now it's cannot exceed $150 per applicant. Okay. And that's in connection with any sale or leasing of a unit. So if you have someone that wants to, purchase a unit or lease, you can charge an application fee or a transfer fee up to $150 per applicant. Okay. And that would basically cover the cost of, processing the application or doing a background check on the applicant, provided you have the authority in your governing documents to approve such individuals. Okay. The authority to charge that fee has to be set forth in your declaration or in your bylaws or in your articles. Typically, you would find that authority in the declaration. Some of the older documents might not have that authority in it, so you might need to amend your governing documents, your declaration or your bylaws to give you that authority to charge a transfer fee. Okay, now husband and wife, and then parent and dependent child are considered one applicant. So you could only charge one application fee for those individuals. Now, if you have a lease or a sublease that is up for renewal, okay, as long as the tenants who are renewing the lease are going to stay the same, there's going to be no additional applicants, then you cannot charge a new transfer fee in connection with that lease renewal. Okay. Now, security deposits. Okay. The statute also says if authorized in your declaration or in your bylaws, you can charge a security deposit in connection with a lease. Typically, the security deposit is going to be up to 1 month's rent. Okay. And if you have the authority to charge the security deposit, that deposit is only intended to protect against damage to the common element or association property that might be caused by the tenant or the tenant's guests or family members. Okay. So this security deposit is really not intended to be applied towards any future assessments if the owner becomes delinquent or for any other situation. Okay, it cannot be applied towards a violation of any sort. Okay, it's purely to cover any damage to the common elements for association property. All right, estoppel certificates. So this will come into play if you have an owner that is trying to sell a unit in the condominium. Okay, now the statute specifically addresses estoppel fees. And it says within 10 business days of receiving a request for an estoppel, the association has to issue an estoppel certificate and must identify certain information that's requested on the estoppel. Okay, now the statute actually tells you what a sample estoppel certificate must look like and the type of information that it must disclose. Okay, so I've listed here on the slide some of the information that you'll be required to disclose on the estoppel. Okay, importantly, there's a big section requesting information on assessments. Okay, the amount of your regular periodic assessments, the date that assessments are due. They'll ask you for information about any other assessments, any special assessments, okay, that might be owed. Now, it would also ask you, for example, does the association charge a transfer fee in connection with any sale or lease approval rights? Okay. It will also ask you, are there any open violations of your governing documents or rules? So, this is important information that you want to make sure to disclose on your on the estoppel certificate so that the selling owner and the buyer can address prior to closing. Okay, so that fees can be paid, assessments can be brought current, and then any outstanding violations can also be addressed. Okay. Now, the statute also provides a fee schedule, okay, of what an association can charge in connection with responding to an estoppel request. Now, these fees are updated by the division. So these fees here are the current updated fees. That is not These are not the fees that are in 718 presently, because they have since been updated by the division. Okay. So for example, if the owner is not delinquent in any amount to the association, then the association can charge up to $299 to respond to an estoppel request. If the owner happens to be delinquent, you can charge an additional $179. If the requester is asking you to respond, within less than, I'm sorry, I didn't mention that the response has to be made within 10 business days of receiving a request. But let's say the requester wants to put a rush on this. Okay, if you can provide a response within 3 business days, you can charge an additional $119 fee. Okay. If the association fails to deliver the estoppel certificate within the 10 business day time frame, okay, then the association is barred from charging a fee for preparing the estoppel. Okay. Now, if you happen to receive an estoppel request for multiple properties owned by the same owner, then the statute also provides you with a separate fee schedule of what you can charge in connection with those parcels, which is right here on the slide. Okay, and as I had mentioned, these fees, the original fees are in the statute, but they can be adjusted every 5 years in an amount equal to the total of the annual increase of the 5-year period according to the Consumer Price Index. So the DBPR, Department of Business and Professional Regulation, which regulates condominium associations, they will recalculate and they will publish a new fee schedule when it's due. Okay. Now, an estoppel certificate that's delivered by hand or by email, it's effective for 30 days. And estoppel certificates delivered by mail are effective for 35 days. So if the closing doesn't take place within this time frame, typically you might receive a second estoppel request. Okay. We just talked about. Okay. The association can also charge a reasonable fee to a purchaser or the current parcel owner or a member for providing good faith responses to requests for information on behalf of the purchaser. As long as the fee does not exceed $150, and you can also charge reasonable attorney's fees that the association might incur in responding to any additional questions that a buyer might have. The association or its authorized agent, they're not liable for providing such information in good faith pursuant to a request if the person providing this information on the estoppel includes this disclosure. The responses here are made in good faith and to the best of my ability as to their accuracy. Okay. Now, other purchase and sale disclosure documents that you might encounter are the condo question and answer sheet. Okay, that is a form that you can obtain from the website of the Division of Condominium, and it's called Question and Answer Sheet. It's a single page, and it's going to have multiple questions regarding your condominium. You know, what are your use restrictions? What are the voting rights of the owners? What are assessments are paid by owners? Is the condominium subject to a recreational or land lease? Do you have to pay any rent on that land lease? And there's also a question about any litigation that the association is currently subject to, in which the amount in dispute is $100,000 or more. So you'll want to make sure that you respond to this question and answer, that you have questions already prepared, okay? And then your question and answer sheet will become part of the official records of the association. Okay. Now, for all residential sale transactions, the selling owner also has a duty to provide the buyer notice of all hidden defects. The selling owner also has other disclosure requirements, okay? These are some of the other documents that the selling owner has to provide to the buyer. Copy of the declaration, articles of incorporation, bylaws, rules, the frequently asked question and answer sheet, okay, and a governance form. Now in this slide, I've identified what this governance form has to identify. And it's a form, again, that you can obtain from the division. The governance form will essentially address the role of the board in conducting day-to-day affairs, the board's responsibilities, the rights of owners to attend and speak at meetings. It'll also include owner's right to inspect and copy association records, remedies available to the owners, the voting rights of owners. So you'll want to make sure you have a copy of this governance form from the division. All right. Use right suspension, voting suspensions, and fining. Okay. So the association can do two things. They can fine and they can suspend the use rights of an owner or the owner's tenant, occupant, guests, invitees from using certain common facilities, common elements, if they are in violation of the governing document or association rules. So you can fine and you can suspend. Now, if you fine or suspend for violations of the governing document, that has to be done in a two-step process. The first step is that the board needs to adopt the fine or the suspension, what facilities are being suspended. And then once the board adopts the fine or suspension, the committee, whether you call it a fining committee or a grievance committee or a suspension committee, that committee has to meet to then vote on whether to confirm or deny the fine or the suspension that's been adopted by the board. Okay, now that committee hearing has to take place at least 14 days from the date that you send notice to the owner of this hearing. And only if the committee confirms the fine or suspension can it be imposed. So the role of this committee is not to negotiate the fine, it's not to negotiate the suspension. It is a yes or no vote. Okay, yes for the fine or suspension or no. Okay, now the committee has to be impartial, consists of at least members who are not officers, they're not directors, they're not employees of the association, or the spouse, parents, children, siblings of any officer, director, or employee. Okay, so for some communities, maybe yours, it might be difficult to find such impartial committee member. And therefore, fining suspension might not necessarily be a useful tool for enforcement. Okay. Now for fines, the fine cannot exceed $100 per violation or $1,000 in the aggregate, with each day of continuing violation basically considered a new violation. So if you have a restriction that prohibits the parking of commercial vehicles on your condominium, and the owner, after you've notified the owner to remove the commercial vehicle, he continues to park his commercial vehicle, For each day that this owner keeps this vehicle on condominium premises, you can fine him up to $100 per day, maximum $1,000. Now with condominiums, unfortunately, the way the statute is currently drafted, the fine cannot become a lien. Okay, so after you've gone through your steps of adopting and then imposing the lien, you'll notify the owner. And if the owner does not pay the fine, then essentially the fine will just sit on the account ledger and hopefully it'll get paid at time of sale. Okay, but you will not be able to adopt this fine as a special assessment against the owner and then lien and foreclose on the unit for it. If the committee does confirm the fine, then it will be due within 5 days after the date of the committee meeting. Okay. Now, you can also suspend voting rights. I think the voting rights is the next slide. Okay. You can also suspend use rights if an owner is more than 90 days delinquent on a monetary obligation to the association. Now, monetary obligation can be assessments, it can be fines, attorney's fees, interest, or costs, okay? As long as the owner is more than 90 days delinquent, you can suspend use rights. Now, suspending use rights due to a delinquency, that can be done by the board at a board meeting without having a committee ratify the vote. So you would just need a notice of the board meeting posted 48 hours in advance, and then the board can make motions and take action at that board meeting. Okay. Suspensions, again, apply to the owner as well as to the owner's tenants, guests, occupants, or invitees, if applicable. And typically, use rights that you can suspend would be those to use common facilities, such as the pool, clubhouse, gym, if you have the ability to regulate access into these areas. So, for example, if an owner needs a key fob, then you can deactivate it after the board properly suspends use rights. This does not, however, apply to limited common elements intended to be used only by that unit. So you can't suspend use rights to a balcony. Okay. It also does not apply to common elements needed to access the unit. So you can't prohibit an owner from using the hallway, for example, or to utilities. So you can't disconnect utilities if the owner is in violation or is delinquent, and you can't suspend use rights to parking spaces or elevators. Now, you can also suspend voting rights if the owner is more than 90 days delinquent in any monetary obligation due to the association. The delinquency, however, has to be greater than $1,000. The owner has to also be delinquent for more than 90 days. And you must provide the owner notice of delinquency at least 30 days before the suspension takes place. Okay. Now, suspension of voting rights, again, this is something that can be done by the board without a committee hearing. Now, there's this case that came out in 2020 which suggests that in order to properly, in order to have the ability to suspend voting rights, you have to have the authority in your declaration. Okay, this applies specifically if you're a condominium that has an older declaration of condominium and you don't have that Kaufman language that amended from time to time. Okay, so if you don't have that language amended from time to time, okay, then the court interpreted that this change to the statute that allowed associations to suspend voting rights did not apply to this particular condominium. And so in an abundance of caution, if you don't have Kaufman language, then you will want to consider amending your declaration to specifically give you the authority to suspend voting rights. Now, if you suspend voting rights, that could be a useful tool, okay, if you're trying to, pass certain, have owners take certain action for the condominium. So for example, if you're trying to amend your governing documents, okay, and you have, let's say, a high threshold to amend your documents, suspending voting rights, okay, will reduce the voting percentage that you need to get quorum, as well as the voting percentage that you will need to get those amendments passed. So if you have a condominium that has 100 units and you need a majority of those to approve an amendment, which would be 50% plus one, and let's say you suspend the voting rights of 10 owners, well, now your quorum is a majority of 90 as opposed to a majority of the 100 units. And you would need to get a vote of a majority of the 90, not a majority of the 100 unit owners. Okay, member meetings. All right, so you will have, there's two types of membership meetings that you could have, okay? It's either going to be your annual election meeting, or it could be a special membership meeting. Okay. Now, for annual meetings, typically your bylaws will dictate the date, time, and location of when you have to conduct your annual election meeting. Okay. Your election will occur at your annual meeting, or in addition to the election, you might have other agenda items that you might want to take up at your annual meeting. But at the very least, you're going to conduct your election at the annual meeting. Now, special membership meetings, they're typically held when either called by a majority of the board or upon the request of at least 10% of the owners, unless you have a different percentage set forth in your bylaws. Okay. Now, notice of membership meetings, whether it's your annual or your special membership meeting, typically it can either be mailed and delivered, or it can be electronically transmitted to those owners who have consented to receiving official notices from the association in writing. So if you have a unit owner roster with emails from these owners, unless these owners have consented in writing to receiving notices from the association, okay, you should not be sending official notices to them via email. As a courtesy, maybe, but then the official notices have to be either mailed or hand delivered. Okay. Now, typically, unless your bylaws say otherwise, notices of special membership meetings have to be mailed, hand delivered, or electronically transmitted at least 14 days prior to the meeting. This is not the case for annual meetings. We'll talk about the notice requirements for annual meetings. So the 14-day notice really applies only to special membership meetings. And then all notices for annual or special membership meetings They all have to say what the date of the meeting, the time, the location, and then identify the agenda items. Okay. Now, proof of notice typically comes in the form of affidavit. So whoever provides the official notice, whether it's your secretary or your property manager, they would have to complete an affidavit, have it signed and notarized, confirming that proper notice was provided for your annual or special membership meeting. Now, for special membership meetings, you might call one for really any action for which owners are required to vote. So typically that might be, amending your governing documents, or on the questions of waiver or partial funding of reserves. Okay, really anything that requires an owner vote will be done at a special membership meeting, unless you take it up as an agenda item at your annual meeting. Okay. Now, quorum at membership meetings, unless a lower number is provided in your bylaws, quorum will typically be a majority of the voting interest. And then, unless otherwise provided in your bylaws, decisions at membership meetings typically are made by a majority of the voting interest at which a quorum is present. Members have the right to speak at meetings with regard to any agenda items up to 3 minutes. The association can also adopt rules governing the frequency, the duration, and the manner of member statements. So you can adopt rules regarding owners attending and speaking at meetings. Owners are also allowed to record and videotape meetings. Now, for membership meetings, voting can be done, okay, either in person by ballot or by proxy, okay? And there are 2 types of proxies. There's general proxy, and then there's limited proxies. General proxies allow a proxy holder to vote however he or she sees fit on any matter undertaken at a membership meeting. Limited proxies, okay, are required under the statute for specific purposes. Okay, so if you want owners to vote to waive or reduce reserves, that has to be done by limited proxy, not a general proxy. If you want owners to waive or reduce certain financial reporting requirements, also done by limited proxy. Any vote to amend your governing documents, right? Or any other matter which, otherwise requires a membership vote in accordance with the Condominium Act or your governing documents will require a limited proxy. Okay? The difference with a general and limited proxy is that the limited proxy is actually going to identify the specific action that you want owners to take. So on the question of an amendment, it would specifically identify the proposal. It could say something like, do you approve the amendment to Article 5 of the Declaration? Yes or no? Okay. And so the owner that is not able to attend the meeting can then fill out the limited proxy, check off how he or she wants to vote, signs the limited proxy, and then returns it to the association prior to the meeting. Now, both general and limited proxies can be used to establish quorum. So regardless of how the owner voted on the limited proxy, that proxy is good to establish and confirm quorum. You cannot use a proxy to vote for elections. That has to be done by secret ballot with in and outer envelopes that we'll discuss momentarily. And then proxies are good for the meeting for which it was called and for a period of 90 days from the date of the original meeting. Okay, so proxies are good for 90 days. Let's say you're trying to amend your declaration and you call a meeting for March 1st. March 1st comes, you count your proxies in front of the membership and you don't have enough proxies to pass an amendment. Because the proxy is good for 90 days from that March 1st meeting, you have the option to recess and reconvene that membership meeting for as many times as necessary to try to get the necessary votes up to that 90th day time frame. Okay, now the proper way to do it would be to get a motion from the owners that are present at the meeting. And as long as a majority of those owners in attendance vote to recess and reconvene the meeting, then you can do so. You'll have to make sure to identify in your minutes the date of your next membership meeting. Okay. Now, let's say you called the meeting on the 90th day and you don't receive the necessary votes. Well, then you'll have to adjourn the meeting and the action basically dies then and there. Every proxy is revocable at any time at the pleasure of the member executing it. Now, an option to taking action at a membership meeting is the written consent process in lieu of a meeting. So instead of conducting a meeting, you would essentially mail out to the owners a consent form, okay, which identifies the action. Let's stay with the amendment example. So you will include in this consent form, dear owners, we're trying to amend the governing documents. Specifically Article 5 of the Declaration. If you're in favor of this amendment, please execute this consent form at the bottom and return it to the association. Okay, so really only those who are in favor of that amendment would need to execute and return the consent form. Now, in order to be able to take action by written consent in lieu of a meeting, you do need to have specific authority in your governing documents. More specifically, you might find that authority in your bylaws. And again, those consent forms are good for 90 days from the date of the first executed consent form. So once you receive your first executed consent form, that's when the clock starts. All right, elections. For elections in condominiums, there is no quorum requirement to conduct the election. The only requirement that there is to have at least 20% of the voting interest cast a ballot. So if you have kind of minimum of 100 unit owners, then you need at least 20 ballots, election ballots cast to conduct an election. If you don't have the 20% ballots cast, then you don't have an election. The existing board essentially rolls over. You would need quorum in order to conduct any other business that you have designated on your agenda. Elections are used, election ballots have to use an inner and outer envelope. We'll talk a little bit more in a minute. But in terms of noticing your elections, okay, these timeframes are all set forth in the Condominium Act in Chapter 718. Regardless of what your bylaws say. And I've seen some pretty crazy language about condominium elections, especially in the older documents, including, you might have something that requires a nominating committee of some sort. None of that is valid. You have to default to what the statute says. And the statute says the first notice of your annual election meeting has to be provided to the owners at least 60 days prior to your election. Again, by mail, hand delivery, or electronic transmission to those owners who have consented to receiving notices by email. Now, those owners who want to run for the board have to provide a notice of intent to run at least 40 days prior to the election meeting. Candidates are allowed to provide what is called an information sheet, basically a sheet of paper, okay, where they might, include a little bit of a biography, who they are, why they're running on the board, and why you should vote for them. if they provide you with this information sheet, which has to be provided at least 35 days before the election meeting, then you will have to include that with your second notice. The second notice of the annual meeting has to be provided to the owners at least 14 days prior to the election meeting. Okay, and again, you'll identify the date, time, location, and agenda items. Definitely the election and any other business that you're going to be conducting. So your second notice is going to not only include this information sheet from the candidates, if they're timely submitted to the board, but also the election ballot. The names of the candidates will be in alphabetical order. Okay. You will also include a general proxy or a limited proxy if you want owners to vote on other issues. And then you'll also include the inner and the outer envelopes. Elections are decided by a plurality of the ballots cast. A vacancy on the board caused by the expiration of the director's term must be filled by electing a new member. Now, if you happen to have, if the number of vacancies equals or exceeds the number of candidates, then you're not required to have an election, and those directors will just be seated by acclamation on the date of your meeting. Now, any documents that you collect in connection with the election meeting, whether it's your ballot, sign-in sheets, inner, outer envelopes, those are all, they all become part of the official records and have to be maintained for at least 1 year from the date of the election. Any challenge to the election process must be commenced within 60 days after the election results are announced. Now, a candidate is any person who is eligible and timely submits their notice of intent. So in order to be eligible, okay, you have to be eligible by the deadline of submitting your notice of intent to run, which is at least 40 days prior to your election. So for example, if you've been convicted of a felony, you're not eligible to run for the board unless your civil rights have been restored for at least 5 years. If you've been suspended or removed by the division, you're not eligible. If you're delinquent on assessments due to the association as of the date of submitting your notice of intent to run, you're not eligible to be a candidate. Again, that 40 days prior to the election, that is your cutoff date by which you have to be current. Co-owners, an association of more than 10 units. Co-owners cannot serve on the board at the same time unless you own more than 1 unit or unless there's not enough eligible candidates. Now, once you become a board member, if you become delinquent more than 90 days on any monetary obligation owed to the association, then as a matter of law, you're deemed to have abandoned your seat. And there's a vacancy that the board can fill. Now, unless otherwise provided in your documents, the board must consist of 5 members. Unless you have a condominium of 5 or fewer units, and then your board must consist of at least 3 members. But that's unless your documents provide otherwise. The terms of the directors expire at the annual meeting. Now, condo term limits. The law was clarified in 2018 that a director can serve a term longer than 1 year if permitted by the governing documents. However, you cannot serve more than 8 consecutive years unless you are approved by 2/3 of the votes cast at the election. Now, this time clock starts as of July 1st of 2018. So if you've been serving on the board for the last 20 years, it really doesn't count Your terms prior to 2018 do not count. Okay, so it's 2018 forward.
And folks, this is why we wait to turn on the Q&A until a little bit later. That was highlighted in blue because that question always comes up. So Kerstin, thanks for covering that.
Now, in terms of the election process, really the first order of business that you will have at your annual meeting is to verify the outer envelopes. Okay, but the statute does provide you with an option to verify these outer envelopes before your election meeting. Okay, you can do so with an impartial committee, and you have to properly notice that meeting at least 48 hours prior to the meeting, and owners can come and view the verification of the outer envelopes. And what this impartial committee is doing is essentially taking the outer envelope, okay, which should have been signed by the voting owner. Okay, the owner must also identify the unit number. Okay, and the committee is literally verifying the signature of the owner against the unit roster and checking off those owners who have voted. Okay, so that process can be done by an impartial committee in advance of the annual meeting. Otherwise, it will take place as the first order of business on the date of the election. Officers. So in the absence of a provision to the contrary in the bylaws, your officers will be the president, secretary, and the treasurer. Your bylaws might provide for vice president and then any additional, assistant secretaries and assistant treasurers. Okay. Officers will serve without compensation unless otherwise provided in the bylaws. Directors cannot vote by proxy or secret ballot, except they can vote for officers by secret ballot. And there's no prohibition against changing officers midstream. So if you don't like the president and you wanted to remove the president from his or her position and appoint someone else, the board can do that. So the officers serve at the pleasure of the board. All right, electronic voting. I'm not going to go into a lot of details with electronic voting, but essentially the board can adopt electronic voting to allow owners to vote on really any issue that requires a membership vote, and they can do so electronically as opposed to by paper ballot and proxies. Okay, the big takeaway here is that the board has to adopt electronic voting by resolution at a board meeting that's noticed at least 14 days prior. Okay. And then the owners have to actually consent in writing to voting online. So they have to opt in writing. Okay. And if they opt in, then they can vote electronically until they choose to opt out. Now, if an owner does consent to electronic voting, then their attendance will be counted towards quorum. Now, the statute does identify what this electronic voting platform has to contain. Okay, you can read that at your leisure. Okay, board of directors. Essentially, officers and directors have a fiduciary responsibility to the owners and must act responsibly. Directors are not compensated, okay, unless otherwise authorized in the bylaws. And typically, bylaws will not allow compensation for directors. So unless otherwise provided in the statute or in your governing documents, really it is the association that will vote on most things. Okay, because it is a function of the board to essentially make sure that the condominium and the association are maintained and operated in accordance with the Condominium Act and your governing documents. Now, meetings of the board. When does the meeting of the board member become a board meeting? Well, a meeting really is any time a quorum of the board of directors get together to conduct association business. That's what the statute says. So what does it mean to conduct association business? It's our opinion that that means when the quorum of the board gets together to vote on issues. Okay. If that's the case, then yes, board meetings should be properly noticed, typically with 48-hour notice. Okay. Now, if you happen to, take action by quorum of the board without a proper notice meeting, then you really should ratify that action at the next properly noticed meeting. That should be your agenda item. Board members can communicate by email, but they cannot use email to cast a vote. An officer, director, or manager cannot solicit, offer to accept, or accept any goods or services of value for which consideration has not been provided for his or her benefit or that of his or her immediate family from any person providing or proposing to provide goods or services to the association. And knowingly doing so can result in a civil penalty. There's no prohibition, however, against an officer, director, or manager accepting services or items received in connection with a trade show. A director or officer charged by information or indictment with a felony theft or embezzlement offense involving association funds or property is removed from office. And if such director or officer is removed, then a vacancy can be filled by the remaining directors. If the charges are resolved without a finding of guilt, then the director shall be reinstated. Directors or officers who have such charges pending cannot be appointed or elected to a position as a director or officer. Now, for board meetings, typically, unless there's an emergency, most meetings can be noticed with 48-hour posted notice. Okay, you'll also identify the date, time, location of the board meeting and just post it in a conspicuous place on condominium association property where you typically post notices. An exception to that is the 14-day notice if the board is going to adopt a special assessment or if you're going to adopt a rule concerning unit use. Okay, for those meetings, you have to mail, hand deliver, or electronically transmit to those owners who have consented to electronic notices in writing. Okay, you'll mail that notice to them 14 days prior to the meeting. Okay, like I mentioned, date, time, location has to be identified on the notice along with the agenda. Now, if 20% of the voting interest petitions the board to address an item of business, then the board essentially has to hold a board meeting within 60 days from that date, okay, to address the item on the petition. Meetings of the board at which a quorum is present are open to all unit owners, with the exception of meetings between the board and legal counsel with regard to proposed or pending litigation, or those meetings for purposes of discussing personnel matters. Owners also have the right to speak at board meetings with reference to designated agenda items. So if there's an item that the owner raises that is not on the agenda, then technically the owner does not have the right to speak as to those items unless the board allows the owner. Okay? Majority of the board present at the board meeting will constitute a quorum. Directors can meet by telephone, okay, or really any other electronic virtual platform, and their presence at such meetings will count towards quorum. Did I skip? Okay, committee meetings. A meeting of a committee that will take final action on behalf of the board or make recommendations to the board regarding association's budget are always subject to meeting notice requirements. They're not exempted, so they have to be noticed just like any other board meeting. Okay? Meeting of committees that do not take final action on behalf of the board or make recommendations to the board regarding budget. They can be exempted, but you need to have an amendment done to your bylaws to exempt these committee meetings from the notice requirements. I've rarely seen that. Okay, condominium association board of directors conflict of interest. Directors and officers and relatives of directors and officers. They must disclose to the board any activity that can be reasonably construed as a conflict of interest. And there's a rebuttable presumption that there is a conflict of interest if a director, officer, or any relative enters into a contract with the association for goods or services, or if the director, or officer, or relative, okay, has an interest in an entity that ends up in a contract with the association. So if you have a director who owns a landscape company, okay, he has an interest in the landscape company, and the association ends up entering into a contract with that company, well, there's a presumption of a conflict of interest there. Now, the statute doesn't say that that type of contract is prohibited. It just provides you with the process of how to properly approve the contract. Okay, so the contract would have to be approved by 2/3 of the directors present at the meeting. Obviously, the interested director will have to recuse themselves. And then at the next regular special meeting of the membership, the board has to disclose that contract. And the owners have the option to cancel that contract. Okay. A contract entered between a director, an officer, and the association that's not properly disclosed as a conflict of interest is voidable. And the contract terminates upon the filing of written notice terminating the contract with the board, which contains the consent of at least 20% of the voting interest. All right. Now, new change to the statute, criminal penalties. An officer or director charged with any of the following crimes must be removed from office and the vacancy filled until the end of the officer or director's period of suspension or the end of his or her term, whichever occurs first. Forgery of a ballot envelope or voting certificate used in a condominium association election. Theft, embezzlement of funds of condominium association is also punishable. Destruction of or refusal to allow inspection or copying of an association record that's accessible to owners within the required period, within the time period required by law in furtherance of any crime is punishable as tampering with physical evidence. So just again to clarify, it's not that if a board refuses to allow owner of inspection of records that it's considered tampering with physical evidence or punishable, is that if you're doing that in furtherance of a crime, you've committed a crime and now you're trying to hide evidence, that is punishable, okay? If a criminal charge is pending against an officer or director for forgery of a ballot envelope or voting certificate used in the election, or refusal to allow the inspection or copying of the official records to the owners, okay, also carries criminal penalties. However, if the charges are resolved without a finding of guilt, the officer or director must be reinstated for the remainder of his or her term. Now, how to get off the board? If you're on the board, there's 6 ways. You could certainly resign in writing, voluntarily resign, or director can also be removed by recall. Board members cannot remove directors. Okay, that has to be done by recall. Or if the director is delinquent in the payment of any monetary obligation due to the association for more than 90 days, you are also, as a matter of law, deemed off the board. Criminal charges involving theft or embezzlement of association funds or property, you're off the board. Or for a knowing or willing violation of the Condominium Act or division. And then failure to satisfy your certification requirements also results in suspension.
Now, I'm not an attorney, but if you want to get off of the board and don't want to do it anymore, I don't recommend committing a crime.
That's the last option. All right. Oh, budgets. All right. The board must prepare an annual budget. Okay, so every year you have to adopt an annual budget of the estimated revenues and your operating costs and then reserves. Now, I'm not going to talk about the CEUs, okay, the structural integrity reserve studies. We talk about that in a bunch of other classes that we teach. So, you know, the reserves referenced here are the, you know, typical reserves that have, you know, been in the statute and remain in the statute. So these reserves apply for any condominium that is 3 stories or less than 3 stories. And they also apply to those condominiums that are 3 stories and higher. So condominiums with 3 stories or higher have the CEUs, and then they still have to comply with these reserves. Okay, this has not changed. Okay, so the budget at a minimum must include the following items, right? These are your typical expenses. Expenses of administration, management fees if you happen to have management company assist with management. You know, maintenance, repairs, costs of insurance, professional expenses. Do you have an accountant? Do you have an attorney on retainer? And if not, you should. Okay. And then any other expense that you incur. If you have a concierge or security service, pool maintenance, etc., has to be identified on the budget. Now, your budget, when you're ready to adopt your budget, you have to mail notice of the meeting at which you're going to adopt the budget, along with the copy of the budget, at least 14 days prior to your meeting. And then the person that's providing the notice and the budget has to sign an affidavit attesting that they've met the notice requirements. If the board makes a change to the budget during the association's properly noticed board budget meeting, it doesn't need to resend the notice of the budget meeting. Because remember, the budget is essentially an estimate, right? You take last year's numbers and you estimate what your new numbers are going to be for the following year. And it's quite possible that when you have your budget meeting, you might have to tweak your numbers once again, okay? Now, as of 2021, the board is now required to adopt an annual budget at least 14 days prior to the start of the association's fiscal year. So your bylaws will typically provide what your fiscal year is. Is it a calendar year? Or does it start in July? So, you know, check your bylaws on that. So your budget has to be adopted at least 14 days prior to the start of your fiscal year. Now for reserves, your budget has to have two components. We talked about the operating part of the budget. It also needs to include a schedule of reserves for capital expenditures, deferred maintenance. Okay, so some examples of capital expenditures, deferred maintenance could be, pavement resurfacing, roof replacement, balcony restoration. Okay, now the statute says you must include reserves and fully fund reserves for these categories: roof replacement, building painting, pavement resurfacing, and then any other item that has a deferred maintenance expense that exceeds $10,000. So you might have elevators included in this category, or any type of pool maintenance, or maybe you have, pool resurfacing, or you have a seawall that would fall in this last category. Okay, you should have reserve studies done. Again, I'm not talking about CEUs. Okay, where professional comes and professional looks at these items and then provides you with a reserve study. Okay, and the reserve study would include information that you would need to include in your reserve schedule. So at a minimum, it will need to identify what is the remaining useful life of this reserve item. What is the remaining useful life of the roof? What is the estimated remaining useful life? What is the estimated replacement cost? And what is the estimated fund balance? Okay. All right. Waiving reserves. Okay. You have to fully fund your reserves every year. However, you can also, the business decision, give the owners the option to either waive reserves or partially fund reserves. Okay, so again, you have to fully fund, but you can give the owners the option to either waive or partially fund reserves. And if you give the owners this option, okay, then owners would have to approve either the waiver of reserves or the partial funding of reserves by vote of the majority of the voting interest. The statute used to say you needed a vote of a majority of quorum. It has made it now more difficult. So now you only need a vote of majority of the voting interest. A vote to waive or reduce reserve is only applicable for the budget year the vote was taken. If at the meeting you don't get the necessary votes to either waive or reduce partial fund reserves, then essentially fully funded reserves go into effect. If you have reserves for certain items, you can only use those reserve funds for those particular reserve items. So if you have straight line accounting, okay, for reserves, let's say you have reserve funds for your roof replacement, okay, you can only use those funds to replace the roof. You cannot use those funds to paint the building or to fix your pool, unless a majority of the voting interest approves the use of these funds for alternate purposes. Okay, so you need to go and get a vote of the owners before you use funds for reserve funds for alternate purposes. If you have separate accounts for reserves and you want to pool your reserves, that is an option, but again, you need a vote of the owners for that. And the vote that you need is, again, a majority of the voting interest. Now, when you present to the owners the option of either to waive or partially fund reserves or use reserves for alternate purposes, you have to provide this disclosure, this statutory disclosure on the limited proxy and then on the ballot, that waiving of reserves in whole or in part or allowing alternate use of existing reserves may result in a unit owner liability for payment of unanticipated special assessments regarding those items. Okay. Financial reporting requirements. Okay, in addition to adopting the budget within 90 days after the end of the fiscal year, or annually as provided in your bylaws, the association has to prepare a financial report of last year's preceding year's fiscal year. Okay, and then you have to provide a copy of that report, or at least notice of its availability, within 21 days after the financial report is completed, but no later than 120 days after the end of the fiscal year. Okay. Now, the association must provide an annual report to the department, to the division, containing the names of all the financial institutions with which it maintains accounts. Now, in terms of your financial reporting requirement, in accordance with the statute, okay, your financial reporting requirement will depend on your annual revenue. Okay, so if you have an annual revenue of $150,000 or more, but less than 300, you only have to prepare compiled financial statements. Preferably, this is something that your accountant will prepare. You're only required under the statute to provide an audit if your total annual revenue is $500,000 or more. Unless, of course, your bylaws require an audit regardless of what your annual revenue is. So if your bylaws say you need a financial audit every year, then that's what you have to do, regardless of your revenue. All right, a few other points. I'm going to try to rush through the next few slides. Meeting minutes. All board meetings should have minutes. Okay, now they're not required, they're not supposed to be really a verbatim record of everything that took place at the meeting. Okay, your minutes really should reflect who was in attendance, the motion that was made, how the directors voted for it, okay, who abstained of any votes, and then, you know, you might include, if depending on the issue, any, you know, specific comments or any specific issues discussed. But other than that, again, not supposed to be a lengthy verbatim record. Outgoing board committee members must return official records and any property that they have in their possession within 5 days after the new board or committee members are elected. And then the outgoing board members who willfully or knowingly fail to return records are subject to penalties. Access to units. The association has an irrevocable right to access a unit for purposes of undertaking maintenance responsibilities regarding the unit as provided in the declaration, or for purposes of maintaining any common element. Okay? Or in the event of an emergency. Rules and regulations. Look at your governing documents. Typically, the board has the authority to adopt rules and regulations regarding use of the common areas, facilities, and units. But you need to look at your governing documents for that specific authority. It's quite possible that your documents might even require membership approval. I've rarely seen that, but it's quite possible. Okay? If you're going to adopt rules regarding use of common elements, common facilities, that typically only requires 48-hour notice. If you're going to adopt rules concerning unit use, then you need to mail notice 14 days prior of the meeting. Once the rule is adopted, you have to notify the owners by mailing a copy of the rule to the owners so that they are aware what the new rules are. Okay? And then the rule becomes effective. Maintenance, look at your governing documents. Okay, there should be a maintenance section in your declaration. Okay, we'll tell you what the association is responsible for maintaining, what the owners are responsible for maintaining. Often boards think that, you know, owners have certain responsibilities with regard to certain items like pipes. Okay, you really have to look at your governing documents to really determine who's responsible for what. Now, alterations, material alterations to the common elements. Okay, if you're going to change the exterior paint of your building, the division has said that's a material alteration, right? The statute now says that if you're going to do an alteration, it requires a vote of 75% of the owners unless your documents provide otherwise. So look at your declaration, see what it says for material alteration. Now there is a maintenance exception to this alteration provision. If you're going to take an alteration that is part of a necessary maintenance exception, if it's part of a maintenance obligation that you have, then it's quite possible that the alteration might fall in that exception and you might not need to get the membership approval. It really is on a case-by-case basis, and you really should consult with legal counsel of whether you need membership approval in that instance. I provided here the definition of what material alteration is. It has been defined in case law. Okay, and then some examples for you to read once you get this outline. All right, emergency powers, not really going to talk too much about it. Just know that really this section of the statute was highlighted as a result of COVID. Okay, and unfortunately, everybody learned that the statute was just deficient in addressing situations like COVID. And so it was amended in 2021 to really strengthen the ability of the associations to operate in states of emergencies. Okay, so you can read some of the changes, which are highlighted in blue. Okay. All right, leasing. So whether or not you can approve or disapprove tenants really will depend on the authority you have in your governing document, specifically your declaration. Okay, so you really have to look to your declaration for specific authority in that. Presuming you have the authority to disapprove tenants, you really should have good cause basis for doing that also spelled out in your declaration. That's preferably, but at a minimum as a policy or rule. Okay. All these types of restrictions really should also be in your declaration as opposed to a rule. Okay. So if you have a rule that says you can only lease, one time in a 12-month period and for a term of no less than 6 months, really those types of restrictions should be in your declaration as opposed to a rule in order to be enforceable. And we talked earlier on that the statute says that if you're going to amend your declaration to prohibit leasing or affect leasing, then that amendment would only be enforceable against those owners who vote in favor of the amendment, and then those owners that take title after the effective date of the amendment, which is when it's recorded in the public records. Now, amendments to your declaration. If the declaration is silent, then any amendment to your declaration will require a vote of 2/3 of the membership. So look at the amendment section of your declaration, see what vote percentage is required to amend. If you have a high percentage approval, then you might want to consider first proposing an amendment to the membership to reduce the voting percentage. And then once that amendment is approved and it's recorded in the public records, then consider submitting to the owners the substantive amendment to vote on. That will likely increase your chances of getting the amendment approved. The way you would need to amend the declaration or really any other document, the articles or bylaws, is really you're going to have to type up the section you're looking to amend, and then any words that you're adding would have to be underlined, and anything that you're removing will have to have a strike through. Okay. unless the changes that you're trying to make are so substantial, okay, that might, hinder the, the understanding, the amendment process, in which case the law does allow you to just type up the amendment you're looking to get approved without the underlines and strike throughs, but then put language at the top of the amendment that says substantial rewarding of the declaration or of this provision, and then look to the original declaration for the existing text, words to that effect. All right. Attorney hiring restriction. Essentially, an association may not hire an attorney who represents a management company of the association. That should be self-explanatory, but I'm going to say it anyways. All right. Vehicle charging stations. So essentially, in 2018, Chapter 718 was amended to now allow owners to install electric vehicle charging stations. Okay, so essentially, your documents, your declaration cannot prohibit owners from installing charging stations if they submit or make a request to the association. Okay. Now, there are certain things that the association, can require. For example, the unit owner who's installing the charging station is responsible for the costs of the installation, the operation, maintenance, and repair. Okay, if the owner will no longer need the charging station, then the owner is responsible for the cost of removing it. Okay. The association can also require the owner to comply with certain safety requirements consisting with the building codes and the installation of the charging station. The board can also adopt reasonable architectural standards as to the dimensions, the placement, or the existing appearance of the charging station. So while you can't prohibit an owner from installing one, you could adopt reasonable standard as to these criteria that's set forth in the statute. Okay, you can also require the owner to engage a licensed registered contractor or engineer, okay, to make sure that the installation meets all applicable code requirements. The association can also require the owner to provide a certificate of insurance naming the association as additional insured on the owner's insurance policy. Okay. Now, the association also has the option of installing on its own a charging station on common element parking spaces that have not been assigned to unit owners. Okay. Now, the statute does specifically say that if the association is the one that's installing the charging station, that installation will not constitute a material alteration to the common elements, and so it would not need to get membership approval for that purpose. Okay. All right, disputes. So the statute specifically defines what a dispute is, which would be subject to the mediation arbitration procedures before the association can file legal action in court. Okay. So disputes that are not subject to pre-suit mediation or arbitration involve collection of assessments, fines, or other financial obligations, including attorney's fees. So if you have an owner who's delinquent and you're trying to collect and foreclose, you're not required to go through mediation arbitration. You are required, however, to go through the pre-lien and pre-foreclosure notice procedures, which we'll talk about in a minute. Okay, but you don't have to mediate or arbitrate before you record a lien and then foreclose. Any action to enforce a prior mediation settlement agreement eviction or removal of a tenant or occupant from a unit. So if you have, for example, a tenant that's a nuisance tenant and you're looking to remove them from the unit, or you have a tenant or an occupant that hasn't been approved in accordance with your governing documents, right? Then under the statute, you don't have to go through mediation arbitration. You can go ahead and file a lawsuit against the owner to force the removal of the tenant or occupant, okay? Alleged breaches of fiduciary duty by one or more directors. So if an owner has a claim for breach of fiduciary duty against a director, they don't have to mediate or go through arbitration. They can go ahead and just file the lawsuit against the director. And then recall and election disputes are also not subject to pre-suit mediation arbitration. Now, disputes that are subject to pre-suit mediation involve use of or changes to the parcel. So for example, if an owner did some kind of alteration to their unit without obtaining board approval, if that's required in your document, or if the association undertakes a material alteration to the common elements without getting the membership approval, that is a dispute that would have to go through mediation arbitration before the board or the owner files a lawsuit, depending on the issue. Amendments to association documents would also be subject to pre-suit mediation arbitration. Meetings of the board or membership meetings. Okay, if you didn't properly notice meetings, that's subject to pre-suit mediation arbitration. Access to official records, and then covenant enforcement. So if an owner is not, complying with what they're supposed to, they're not properly maintaining the unit, or if the owner is becoming a nuisance, okay, you'd have to go through pre-suit mediation arbitration before you can file a formal lawsuit against the owner to force the owner to comply. Now, it used to be that you would have to file arbitration. Okay, mediation was not an option before. Now it is. Now you don't actually have to go through arbitration. You can immediately request mediation as opposed to arbitration. And if you do, you essentially, after you've gone through your normal violation process, okay, with your violation notices, initially from the association or management, and then from legal counsel, and you're ready to move on to the next step, then you'll probably have your legal counsel send a demand for pre-suit mediation. This is more for your attorney to deal with, but just so you're aware of what the pre-suit mediation notice has to include. It has to identify at least several proposed mediators, which the parties now have to choose from. Okay, and the respondent has to respond to the request for mediation within 20 days of the date of mailing the offer. Okay, now both parties are required to share the cost of pre-suit mediation. Okay. Now, if there's an impasse, and impasse can be if the respondent, in this case, let's say the owner, fails to respond to a pre-suit mediation offer within 20 days, or fails to agree to at least one of the mediators that was suggested. Okay, or if the owner fails to make a payment of the mediator fee within the time frame designated, or fails to appear to the scheduled mediation, okay, then that's considered an impasse. And the association can then proceed in filing a legal action in court, okay, without further notice. Now, the division of condominium has jurisdiction over election irregularities, board recalls, failure to properly conduct meetings, official records violation, requiring an owner to take action or refrain from taking action, improper alterations, and like I mentioned earlier, non-binding arbitration of disputes is no longer mandatory but optional. Condominium division arbitration does not apply if you have an issue concerning title to a unit. So typically this is when, let's say, an owner buys into a community without prior approval. Now you're seeking to void title. You wouldn't have to go through arbitration mediation. You can file a lawsuit directly against the owner on that issue. Interpretation or enforcement of any warranty, levy of a fee or assessment, like I mentioned earlier, eviction or removal of a tenant, or alleged breaches of fiduciary duty. If you do decide to go through arbitration as opposed to mediation, either party has 30 days to appeal the decision, and if not, the arbitrator's decision becomes binding on the parties. Okay? You have to enforce the decision in court, and any appeal obviously has to go to the circuit court. If you elect arbitration, the prevailing party is entitled to recover attorney's fees. Okay. I'll leave this additional arbitration information for you to read at your leisure. Essentially, if the owner fails or refuses to participate in the mediation process and then prevails, he or she is not entitled to recover attorney's fees in any subsequent litigation relating to the dispute. Okay. Okay. Quickly, condominium websites. If you have an association with 150 or more units, you have to create a website. This was a law that took effect January 1st of 2019. The statute identifies essentially what this website has to look like, the minimum requirements of this website. You can read that at your leisure. And then it also identifies basically all the records that would have to be posted on this website. Again, for condominiums of 150 units or more. I can tell you that if you don't post certain records and an owner files a complaint with the division does take jurisdiction, okay, and will investigate and could subject the association to penalties. All right, official records. Just quickly here, the official records are comprised of all these documents, okay? So when you get this these slides, you can read through them. Number 14, this is the catch-all provision. All other written records of the association not specifically listed, or which are related to the operation of the association. Okay. You have to keep all the official records for at least 7 years, with the exception of the board certification, which you have to keep for 5 years, and then any election materials you have to keep for 1 year. Except the following records have to be maintained from the inception of the association. So, copy of the plans, permits, warranties, or other items provided by the developer, your declaration, your bylaws, your articles, your rules, and then all meeting minutes. They have to be kept forever and ever and ever. Bids for work. They have to be maintained for at least 1 year. Renters also have the right to inspect official records of the association, but they only as to the declaration, bylaws, and the rules. That's it. Now, the statute also identifies the records that are not accessible to unit owners. Okay. So there's a laundry list, which includes, records that are protected by attorney-client privilege, medical records, personnel records of the association or management company, social security numbers, driver's license number, telephone numbers, email addresses, unless the owner has consented in writing to the disclosure of the phone numbers and email addresses, okay? So any record protected by attorney-client privilege, okay, that is exempt. And really, again, it's only the board that can waive attorney-client privilege, not the attorney. The official records have to be maintained within 45 miles of the community of the county. Okay. And you have to provide owners with access to inspect the official records within 10 business days of receiving a written request. The statute has since been changed. It changed last year to now say that owner and the owner's authorized representative are entitled to inspect records at the same time. It used to be owner or the owner's authorized representative. Now both can appear at the inspection. The right to inspect includes the right to make copies.
I'm just going to mention, folks, that the Q&A is now open. Many questions that typically come up have already been answered during this presentation, thanks to Kerstin. And for those of you who emailed me questions, there's a couple of you that have, please put that into the Q&A. We'll get to as many of those as we can. They will be chosen at random, and they must be on topic and not too specific. We likely won't get to all of them, but we'll get to as many as we can. The evaluation link is also now in the chat. So you also can place a question into the evaluation in field number 10. Sorry for the interruption. I'll go over the evaluation a little bit later.
Yeah.
Back to
We have
you.
about 10 minutes. We have about 10 minutes, so I'll just go a few more slides and then just open it up for Q&A. Just note that if an owner is denied access to official records, they are entitled to damages. Okay, the minimum damages are $50 per calendar day, up to 10 days, and that starts on the 11th working day that records were denied. Contracts and bids. Big takeaway here is really all your contracts should be in writing for all types of services. Okay. Now, if the aggregate cost of the contract exceeds 5% of the annual budget, including reserves, you are required to obtain competitive bids. In my experience, most boards get bids anyways. Probably the prudent approach. Okay. Now, certain types of contracts, you're not required legally to obtain bids, and those are contracts with your professionals such as attorneys, accountant, architect, manager. Let's see here. Bulk communication contracts. These refer to, let's say, your internet or your cable contract. Okay, typically boards are authorized to enter into bulk service contracts, and the cost of paying for the service is a common expense. Okay. Now, the cost can be allocated on a per unit basis, even if your governing documents provide for other than equal sharing of operating expenses. So if owners in your condominium share expenses depending on the percentage of ownership in the common elements for bulk services, bulk service contracts, that particular common expense can be allocated per unit on a per unit basis. Let me just quickly go into collection foreclosures. and then I'll be done. So with collections and foreclosures effective July 1st, 2021, sorry, this is the slide that I wanted to get to. Effective July of 2021, the association cannot require an owner, a delinquent owner, to pay association attorney's fees in connection with a delinquency unless the association first sends notice of delinquent assessments to the owner, giving the owner essentially 30 days to pay their account. Okay, this is not the pre-lien letter. Okay, before you can lien an owner on delinquent amount, you have to send an owner 45 days in advance, letting them know that they're delinquent and give them an opportunity to pay. And if not, you're going to lien the unit. That's different from this. This is sort of the initial letter before you even get to the pre-lien letter. Okay, you have to give an owner 30 days to pay their account. Okay. You cannot charge attorney's fees in connection with this letter. Typically, this is a letter that your management company will send. Okay, it has to be mailed by just regular U.S. mail, and it has to be mailed to the owner's address that is reflected in the association records. Okay, and then you need to have an affidavit signed by whoever sent out that notice, attesting that this notice was properly mailed out in accordance with the statute. Okay. All right, I think I'm going to stop here.
Thanks, Jeff. So there's a couple questions, Kerstin, on, and I know I've heard this, maybe you can elaborate. There's a few different questions on estoppel rules changing. I know that I've heard that there's something new in the legislation about estoppel rules changing about the payment of the estoppel. And I had a couple questions from a few different viewers regarding that. Can you elaborate a little bit?
Yeah, I mean, the legislation that is being proposed essentially is trying to eliminate the ability of the association to charge for preparation of these estoppel fees. You know, not very thought out legislation. I mean, there's a lot of time involved in answering these estoppel requests from, management's perspective. Certainly, if we are ever requested to respond to these estoppel requests, we have to pull the accounts, check for delinquencies. So, it's not just a 5-minute thing, right? And ultimately, if the association asks for legal counsel, for example, to prepare the estoppel, we're going to charge a fee, right? I mean, that's only, natural. And so now the association is kind of stuck with this expense that they can't basically pass through to, the buyer or the owner. But we'll see. We'll see what's going to happen.
Okay. So that answered two of the viewers' questions. There's one question that's kind of long from Val Barrett. Special assessments. This statute requires that notice of any meeting in which regular or special assessments against unit owners are considered specifically state: 1, the assessments will be considered; 2, provide an estimated cost; 3, provide a description of the purposes of such assessments. Can the board randomly modify the notice purpose without an official vote, or does that constitute a statute violation? And can contingency money be used to backfill a special assessment? And in that case, should the purpose of the notice be upheld? That's a loaded one.
It is a loaded one.
Is this something more for their association attorney? It seems very specific. It seems like maybe
the contingency fund issue is something you might want to discuss more specifically with your legal counsel. But I mean, in terms of like what the notice requirements are for a special assessment, I mean, at some point you're gonna have a board meeting at which you're kind of at least starting the discussion of the special assessment, right? You're not necessarily adopting, but you're discussing this is how much we need for this particular purpose. And so, that's when you'll come up basically with the information you need to kind of plug into this notice. So let's see. Oh, I didn't see the question.
Oh, I answered. It's in the answered section. It's the first one. I put answered since we answered it online on air.
I'm not sure what what the question is. Can the board randomly modify the notice purpose without an official vote? I mean, typically you will figure out the amount of the assessment and the purpose at some kind of board meeting, right? Like leading up to the official vote on the special assessment, you probably will have multiple board meetings discussing, the particular contract or particular issue. So I don't know that it's random. I mean, you're going to be doing it at some board meeting. It's just that that wouldn't constitute the official adoption. You're just discussing, okay, we're going to have a meeting at such and such date at which we're going to formally adopt the special assessment. We think that it should be for this amount. And then you have management and legal counsel prepare the notice.
Gotcha. That makes sense. Okay. Regarding power stations, would the association be responsible for owner installed power station? Don't believe so.
No, I mean, that's, the statute specifically says that, well, you can't prohibit the owner from installing the station. Certainly the owner is going to be responsible for all the costs associated therewith.
Okay. There's another viewer asking about that they have an annual meeting coming up and they believe that there's going to be conflict. Is there possibility for state supervision? I've never had to deal with something like that, but I would feel if they feel that there's going to be conflict, isn't it best to have their association attorney present during that meeting to answer any legal questions? They feel like there's physical contact. There's going to be like physical conflict. You can always have the police come. I unfortunately have had to do that in cases where we've had tension between residents and board members, and we asked a police officer to be stationed. And then again, if we thought there was going to be conflict and a lot of questions that were beyond the scope of the board or management present, that they would have their association attorney present. Would you agree with that?
Yeah, absolutely.
Okay. Perfect. I don't know about state supervision. Have you heard of anything about state supervision?
Well, yeah, I mean, they can, you can pay to have an ombudsman, like an official, from the division sort of monitor, an election monitor, like if that's the concern.
Okay.
So that's always an option. And I would also just suggest to have legal counsel present there as well.
Yeah, that sounds like the best plan. In regards to reserves, can insurance payments be made from those funds? I believe this is a no.
Right. So, typically with reserves, they're already allocated for specific items.
Cool.
And so in order to use reserve funds for anything other than for which they were originally allocated, you would need a membership approval.
You would need a membership approval. Yeah, that's
now, and that, again, let me just clarify, that is related to non-CEUs reserves. Okay, for CEUs reserves, which would apply to condominium associations with buildings 3 stories and higher, if you fall in the category, okay, starting with the budget adopted after December 31st of 2024, you won't be able to waive reserves, partially fund those reserves, or use those reserves for alternate purposes. So that's going to be a no.
Okay. The next question, are official minutes to be written or electronic or both? I'm a little confused by this. I believe what they're saying is, do they have to put them on a website? So are they, so that's how the question's written. Are official minutes to be written or electronic or both? So I am assuming they mean electronically stored, meaning on a not a public website, but a website that the residents can access. And websites must be maintained for for condo associations that are 150 units or more, correct?
Mm-hmm. Right,
Okay.
so the legal obligation to post these minutes on a website would come in if your condominium association meets this threshold. Okay, otherwise there's no legal obligation to post the minutes, on a website, but certainly you have to keep them filed as part of your official records. Yeah.
And I believe you just kind of answered this last question, not with your response just now. But this person is asking, are condo associations less than 3 stories required to fully fund line by line time the item identified as structural in the Surfside list? I think they're talking about the Sears fully, if they have to fully fund if they're if they're less than 3 stories.
So if you're less than 3 stories, the structural integrity reserve study wouldn't even apply to you. That said, what does apply are the reserves that I talked about earlier on, okay? For your roof replacement, your painting, your pavement, and then any other item whose deferred maintenance or replacement cost is going to be more than $10,000. Those obligations have not gone away.
Yeah.
But for those condominium associations under 3 stories, you still have the option to present to the owners the opportunity to waive or partially fund those reserves.
Gotcha. Another viewer is asking, can a board decide not to enforce portions of the docs or regulations?
That's a big no. I mean, that subjects board members to breach of fiduciary duty. So my suggestion is, if you have restrictions in your documents that just don't match up with how you operate, or which haven't been enforced and you're not really interested, then really amend them out. Just remove them. And removing, I mean, draft the amendment and then have the membership approve the amendment and then record the amendment in the public records.
Perfect. The viewer that asked about the special assessment question, they wrote back, clarification, can the purpose of the original notice be changed after the special assessment has been levied and collected? Meaning, I think what their meaning is, they said, like, we're doing a special assessment to cover the roof repairs, but then after the assessment's been collected, they use that money for other items besides the roof repairs. I think that's where they're going with this.
Okay, if that's the case and you're modifying the purpose, then you really need to readopt that special assessment. Yes, so you'll need a new notice, and you'll just need to, and disclose the appropriate information. Depending on what you're trying to do, you might need to cancel the prior assessments and readopt a whole new one. So that is, really a more specific question for the board's general counsel. Yeah.
Okay. That's good. Hold on, let me go back because I was scrolling down. Can you have an executive session of the board meeting to discuss issues related to a particular unit owner? Example, payment delinquency, violation of rules, etc. I'm a little confused.
I mean, unless you're discussing issues about, existing or pending litigation involving this particular owner with legal counsel present at that meeting, that meeting really should not be a closed meeting. You can talk about the owner's delinquency at an open meeting.
Yeah.
You're conducting association business, so that is perfectly acceptable and appropriate point of discussion at an open meeting.
The next question I have here is from Norman. This seems very, very specific to the community. I would advise that you get this specific question answered by your association attorney. Basically the question is regarding a unit owner that allowed a relative to reside in the unit over a month without board approval, and that relative caused a nuisance within the community, and they're asking, they have forced that resident owner to evict that relative that was causing harm.
Yeah. I mean,
So,
that's really going to depend on the authority that they have in their governing documents. To screen and to evict. I mean, eviction is a term of art. If you mean to compel the removal of an occupant that's a nuisance, then that just involves filing a lawsuit against the owner to force the owner to do the removal. Okay, that typically any association can do. You just need to make sure you have proper documentation of this ongoing nuisance, right? If we're talking about eviction, typically eviction is a landlord-tenant action, right? The landlord files an eviction against the tenant. So in order for the association to kind of step in the shoes of the landlord, there has to be specific language in the declaration of condominium giving the association that authority. In my experience, most of the older documents don't give that authority to the association. So something that typically requires an amendment. But again, that's a very document specific question.
yes, I agree. Hold on, I was just answering a quick one. What are the requirements of the Corporate Transparency Act as it pertains to condo associations? Do all current board members and board authorized committees, which have their own bank accounts, officers have to reveal their personal information required?
It's a loaded question, a little bit beyond the scope of here, but the way that the act is currently being interpreted is that, yes, it seems to require associations, association board members to, file, the required information and disclose whatever information is being requested of directors and officers. But we'll see. We'll see if the statute is later changed to hopefully expressly exempt associations. But for now, my suggestion is go ahead and do your filing.
A viewer wrote, I noticed in the pecking order of the board, Kerstin stated president, secretary, treasurer, and left the VP hanging in mid-air as a know-nothing officer of the board. I think you had gone over, and I believe you had said secretary, treasurers, and presidents are officers, are considered officers of the board. So a director and a VP is not considered an officer.
No, so VP, vice president, is an officer.
Okay.
And the whole point of that slide is that at a minimum, you need to have a president, a secretary, and a treasurer. Now, it's quite possible that, and most documents do, also require a vice president.
Yes.
These are all officer positions that are appointed by the board of directors.
Yes. Because there are some boards that are less than 5 board members.
Yes.
Now, I know the requirement for condo is 5, but like HOAs, and I know this is condo, but HOAs, they can have 3 board members, and it should be at least have your president, your secretary, your treasurer, unless your documents state otherwise.
Correct. Yep.
Must there be a quorum of members for the board to make a decision to approve contract for repairs or to designate committee members? So the committee members, yes, because I would assume that this is going to be discussed at a board meeting. I don't believe the board can just decide we want to appoint this committee member and 2 out of the 5-person board can make that decision. Correct, Kerstin, with what I'm saying?
Typically, right. I mean, unless the bylaws give, specific officers the sole authority to appoint committees, like a president or vice president, and that's quite possible. But unless you have that specific language, then yes, typically it takes, the majority of the board to appoint committees and then designate their authority and their powers.
All right, I'm going to be the bad guy. We advertised to 3:15, so let's do 4:15. I'm in the central time zone. Sorry. Let's do one more question.
Okay, hold on. Let me get a good one. No offense to everybody's questions.
Oh, they're all good.
Actually, they're all good.
They're all good.
Yeah, they're all.
Some of them just
they're
are
all
little
fantastic. Just some are more pertinent than others.
Yeah. Hold on. Let me see. Since you're talking, we are going to go over the certificates again. There are actually a lot of questions about certificates.
Yeah, I'm going to do
We'll
that.
go over
When
again.
both of you skip out, I'm going to stay on and go over all the certificate and
Okay.
technical stuff.
And then, so the last one I will ask, if the association's documents state that partial and waiving of reserves need to be offered, can the board provide fully funded reserves only? That's a confusing one, maybe. Hold on, let me go to another one, because I'm a little confused by that one. Can you send you send a violation once the 14 days expires, you then oppose the fine, then an additional 14-day notice goes out to a committee. And does the fine start once approved or once the committee approves the board's fine? So the way that was worded. So I think they're asking, does the fine start once the board approves it at their board meeting before it goes to that grievance committee, or does it start once the committee approves the fine stated by the board?
Right. So when the board approves the fine, it still cannot be imposed until the committee has had its hearing and formally ratified the fine.
Right.
So the fine would start after the committee has had their hearing and formally voted to confirm the fine.
Perfect. That was a good one.
Okay.
Okay. So
And
that
then
was
it's
our
due
last
within 5
official
days.
question.
Yeah.
Yeah. All right. Well, thank you so much, Kerstin. I'm sorry it was all over the place with the questions, but good questions.
Oh, it's fun. Yes.
Audience members, very, very informative. Lots of information, as you guys all have heard. Like I said previously, before Kerstin started the presentation, Kay Bender-Rembaum does webinars, presentations, seminars, luncheons all the time. I think you guys had something else going on today earlier in the day. There's usually multiple things going on with Kay Bender-Rembaum. So definitely go to their website at kbrlegal.com. They have a calendar. They have a tab that has a list of calendar events. That's where you can click on that event and register. There's usually a register link provided, and there are classes just on these specific topics. So I know that there's a budget class. There's a class regarding elections. So all the little things that Kerstin went over, there are different presentations and webinars offered that elaborate more on those subjects. So with that being said, thank you so much again, Kerstin, for the presentation. That was great. I hope we get to do this again soon. And as always, Jeff, you're amazing. I thank you for putting this on with GRS. And everybody in the audience, again, my email, it's on my video screen if you have any questions regarding today's course. If you want to reach out, again, I'm not an association attorney. I cannot give legal advice. I can answer anything to the best of my ability, and I hope to see you at a future presentation.